Good morning, everyone. Fox 10 investigator Justin Lum here, joined by Special Projects executive producer George Obi as we cover day 8 of the Lori Vallow Daybell trial. But a twist here today because jury's not reporting. As you guys have been watching and following, a big afternoon yesterday, really the finish to this as the state rested its case. And Lori Vallow Daybell also said that she rested her case after saying that the state did not present sufficient evidence to show that she conspired in the murder of her fourth husband. But it's like 99.9% rested for her.
Right. One last cliffhanger in all of this. She is that much closer to resting her case and not taking the stand, but left the window slightly open that she could still do so. And maybe we'll learn that this morning.
Yeah, there's always a cliffhanger. There's always this question keeping us on our toes of what's going to happen. Judge Boreski, who has been quite calm and collected through all of this. 7 days of trial does not feel like 7 days of trial. We have seen a lot. We have heard from 19 different witnesses. Lori Vallow Daybell does not have one to call. So I think the prosecution clearly felt very confident, didn't have to get through all 21 witnesses, finished with lead detective Nate Duncan, and we finally got to see into the window of the affair between Chad Daybell and Lori Vallow Daybell, and what they were saying about Charles Vallow, the life insurance change, spiritual, financial, you name it, it had it all, and not to ignore the shooting that happened involving Alex Cox, who died in December 2019. So a lot of you have questions. Thank you to everyone watching. We have about 300 people watching. Hello to you all. Today's not going to be the most exciting day, but I think it's great that we have a camera in the courtroom and we're able to see jury instructions and how both parties review those, the questions they have, because these are the instructions that the jury will be getting after closing arguments on Monday.
Yeah, and they're going to be pretty easy to follow. You know, we talked about the previous two cases in this saga, how many counts that the jury had to go through, the decision they had to make. So we are at a point now where it should be pretty easy for the jury, once they start deliberating, to make their decision. They have one count, conspiracy to commit murder. I don't know. I know, like you said, this trial has felt like longer than 2 weeks.
Yeah.
But yesterday, so much was introduced. Prosecutor Trina Kay really was her star witness, and we were not shocked, I guess, that we knew she had two more witnesses to call, but I feel like most of us felt like this was really her best witness and probably the best way to end it.
Yeah, I thought that's what we thought, but us looking at the number 21, we just kept assuming, oh, there's two more. Well, why did you not end with Duncan? But she did. Now, obviously, Trina Kay, very experienced, and something as, like I said, this is not going to be exciting today, but we will see the cracks and see the lack of experience on behalf of Lori Vallow Daybell because she's not a real attorney. She's acting as her own attorney. But I was talking to Rachel Smith this morning, special prosecutor on the Idaho case, and she told me, I'm reading the message right now, one of the places most vulnerable on appeal is instructional error. Courts expect trial judges to get it right. So the appellate courts view instructions critically. This is an area that Lori will be most ill-equipped to be her own attorney. And really, it's one charge. It's not like in Idaho where it was first-degree murder in the death of J.J. Vallow and Tylee Ryan, conspiracy to commit murder in the deaths of the kids and Tammy Daybell, and then also grand theft by deception for both of her children. Like, there were a lot of instructions that were very critical and had to be reviewed for the jury to even get those instructions. So this is one charge, conspiracy to commit first-degree murder. So it shouldn't take long, but, this is where she lacks the experience.
Right. We will, I think, get a pretty good idea if she has anything to say today regarding her case moving forward. I thought, as you mentioned, Boreski's done a great job throughout this trial, and I thought he made it pretty clear to her yesterday where she stands and what she needs to do to close this chapter so they can bring the jury in on Monday. Closing arguments. We heard Trina talk about how long it would take her.
Mm-hmm.
Obviously, Vallow or the Daybell, Lori Daybell, indicating her closing arguments wouldn't be nearly as long as Trina Kay's, and that may be good or bad for her or the jury. And then we'll figure out how long they need to deliberate. But like you said, today's developments, they're getting back into the court now. Should be pretty short and sweet. But maybe we'll finally get an answer about Lori's decision to take the stand. Hopefully,
Well, she can't officially rest until the jury's in front of her, and they're not reporting today. So
right.
she actually has more time than we think. She's been thinking about this since last night, or maybe she's made up her mind, and we are not getting that change of mind. Court supposed to start about 10:45. We know that Lori Vallow Daybell and her counsel have already met minutes before this, but at 10:45 they'll start going over these jury instructions. And according to Rachel Smith, prosecutors, they spend a good part of their closings explaining the instructions and the law. How key is that in presenting to this jury of 14 right now what they need to do in order to follow the instructions? And she will ask them to find Lori guilty of conspiracy to commit murder. She says that Trina will probably use a PowerPoint to walk them through that. And prosecuting attorneys always anticipate a jury to have legal questions. So they want to address those things and put them in closing arguments. And that's why she expects to go more than an hour.
Yeah, if I remember correctly, in Rachel's case, the jury had some questions, I think, regarding some of the things they had to decide because there were, like you mentioned, a number of things that they had to weigh in on
Several
in
charges.
their decision. This, again, pretty cut and dry. You've got 12 jurors, 2 alternates. And we go back. The jury has asked a few questions. Most of them have been pretty simple and to the point.
Mm-hmm.
So I would be shocked if they had any other questions at this point. I thought yesterday would have been the day that they would have had more questions than other days.
Yeah, I think as far as evidence, they're done. If they have any questions, it's going to be about these instructions. But really, for one charge, that's why I don't expect this to be a very long day. But who knows? Again, you have someone who is representing themselves and doesn't have that experience. But I think for Trina, this is just dime a dozen. She's done this many, many times. But I would also like to note that Court TV, we know, is the pull camera for this.
Mm-hmm.
They have put in a request to distribute the broadcast of the verdict when the verdict is read live. So it'll be no 30-minute delay if they get their way. If Judge Beresky says, yeah, that's fine. Just like in Idaho, it was live. I think that was huge in the first trial because there's no cameras. And then when we got to the verdict, they had a pool photographer from the Associated Press for stills, and then they had their Zoom camera set up for the live verdict to be read because at this point, the verdict is in. So I don't see that there will be an issue, and you guys will be able to watch that with us live, the verdict being read to see if Lori Vallow Daybell is guilty or not guilty for the death of Charles Vallow. So that's something that we're waiting on and we're tracking. But first things first, these jury instructions, and then, if Lori sticks to this path and does not testify, her best bet, like I was saying to Ron Hoon in Fox 10 Talks earlier, is to present her case in closing arguments. But she didn't really answer questions for the jury, did she? When, not that it's her burden to, but in opening statements, she says the evidence will show that self-defense is not a crime.
Yeah, I feel like if you read into it, I guess from her perspective, she kind of alluded to it in the Rule 20 yesterday, that the state didn't provide enough evidence to prove conspiracy. We talk a lot about in our business, you kind of lay out the dots and let the people at home connect them. I think in court, you could make the same argument. You could certainly use the same justification. Is the prosecution lays out the dots and hopes that the jury connects them like a normal and reasonable person would. Yeah, no, there's no video, there's no audio where Lori tells Alex, look, I need you to kill Charles because I want his money, right? In a perfect world, that's the smoking gun. You don't have that in this. So maybe the jury picks up on that, but they need to connect some of the dots At least that's what the prosecution is hoping, that they see all of this. They read the text messages. They see the demeanor. We've talked a lot about, a lot about Lori's demeanor on the morning of July 11th, and her whereabouts and her leaving after the shooting and how long it took Alex or anyone really to call 911. You hope that those are the dots that they connect, and that the jury sees, okay, do we have the smoking gun for Lori? No. But do we have enough to suggest that she knew more than she's letting on even now? Maybe. I think that's kind of what the prosecution.
And obviously it's easy for us to make more judgments or connect the dots, and we've been suspicious of Lori the whole way in the context of what happened in Idaho. But if you're the juror that hasn't seen any of this until the last week or so, I don't know if it's as easy. I mean, maybe there's one juror that says, "Oh, I don't think there's enough." Yeah, they may think that she acted shady and didn't care about her husband, but they may not think that these weird text messages are enough. We are unbiased and we are fair in our coverage, but we're also talking about a convicted murderer that did not cooperate with authorities at all in telling them where her children were. She lied to many people about how Charles died. So there were just so many red flags in these cases. As journalists, sometimes the truth, what is the hope? The truth is the truth, is finding the truth. And you want to be fair, and she's innocent until proven guilty. But like you said, if you connect the dots, this looks like a conspiracy.
And we obviously know more about, we have more dots to go off of than the jury does, because we know about the other cases. We know about the mounds of evidence related to the children, to Tammy. Like, we obviously can connect more dots and know, okay, there was something more nefarious going on here. Maybe you're right. Maybe there is a juror who's like, look, I need the smoking gun. These dots, all of this factual evidence that you've given us in court, all of that's great, but there wasn't one piece of evidence that pointed to Lori holding the gun with Alex, or, again, we don't know what went inside the home, whether there was a quote unquote fight or not. Yeah. If you can find somebody who knows absolutely nothing about Lori Vallow Daybell, maybe you could make that argument, like, look, guys, this is all great, but nothing here shows me that she pulled the trigger.
And I was talking to friends this weekend, personal, but there are people that really don't know a lot. They know her name, and they have the facts wrong, and they don't really know the entire story, and that's okay. They haven't followed it. They haven't really digested and even tried to digest all of this. So, but will it be harder to find a jury for the next trial? Probably, because every video of Lori Vallow Daybell that's posted online by us or any other media outlet, this trial, whatever is including her and her name, it gets thousands and thousands of views and gets circulated.
And I would think the next case is going to be much harder because there's less circumstantial evidence to tie her to that. We saw some of those texts yesterday, but
okay. So we're about to get started as far as real time, and we'll be tracking what's happening in the courtroom for jury instructions. But we aren't leaving you guys. We'll see you in 30 minutes as that starts streaming. We're going to let you see our last episode of On the Record from last night. See you in a little bit. 7 days of trial, 19 witnesses, and the state of Arizona just rested its case against Lori Vallow Daybell, the so-called Doomsday Mom, also resting her case without presenting any evidence. But there's a twist. She didn't rest in front of the jury. Is there a chance Vallow Daybell changes her mind and testifies to finish her defense against the charge of murder conspiracy in the death of her fourth husband, Charles Vallow? I'm Justin Lum, and we are On the Record. Well, after 7 days, we have closing arguments set for Monday morning at 10:30 a.m. Lori Vallow Daybell resting her case, but not 110% resting her case. We are going to see what happens tomorrow as the court goes over jury instructions, but there is that small window where she could change her mind and testify because she just didn't rest in front of the jury. But she has no witnesses to call, and so I assume no evidence.
Yeah, would you expect anything less from this case? One last curveball. You
Yeah.
know, just one last little curveball. Everything we've been waiting on, would she or wouldn't she? And now we're still left wondering, although, again, like you said, we're pretty certain she's not going to testify. And after today's testimony,
Yeah.
why would you?
After Nate Duncan surprises us all as the last witness when we thought there were two more, I guess, the state doesn't have to follow their exact list of witnesses. They don't have to get through all 21. And obviously, prosecutor Trina Kay felt that Duncan was going to seal the deal. And we will see what happens when a verdict comes out, and if that was definitely an X factor. Nate Duncan, under the weather the past couple of days, comes in today and really answers yes or no and correct to questions about all of the text messages and the evidence regarding Chad Daybell, Lori Vallow, and Alex Cox, and we'll get to that in a little bit. But after the state rested, I think it was interesting that Lori called a Hail Mary just to see if Judge Boreski would just, give me an acquittal, and then, she wouldn't have to answer the question about presenting evidence. But maybe that's just what any public defender would do, any defense attorney. Let's listen to this soundbite where Lori says there's not enough evidence in the case.
Your Honor, I'd like to address a Rule 20 motion first.
Go ahead.
Okay. The state has failed to show substantial evidence for count 1, conspiracy to commit first-degree premeditated murder. The state has provided no evidence that I agreed with another person that any one of us would engage in certain conduct that I intended to promote or assist in this premeditated murder. Crime premeditated murder requires the state to establish a person caused the death of another with premeditation. The lack of evidence to show any evidence of a conspiracy to commit murder, there was no plan to murder Charles. No evidence has showed that, in fact, evidence suggested self-defense on the part of Alex. So I would like to put that on the record.
All right. State want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon everything from the iCloud messages from between Alex, the defendant, and others leading up to July 11th of 2019, that Alex Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles Vallow and the fact that the number of shots and the physical evidence at the scene, the statements by the defendant to Detective N. Clan that she took Charles Vallow's phone and would not give it back to him, the motive for money, and especially the defendant's motive for having an affair with Chad Daybell. All of those looking at together in the light most favorable to the state, the defendant or the jury could find the defendant guilty of conspiracy to commit first-degree murder.
Last word. Do you want to add anything?
No, Your Honor.
All right. The standard is whether or not a reasonable juror whether or not there's substantial evidence for a reasonable juror to find the defendant guilty. The court does find that there is substantial evidence that a reasonable juror could find the defendant guilty. The court will further add that the jurors are the ones who judge the credibility of the witnesses, and it's ordered denying the Rule 20 motion. Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest.
So obviously, Judge Boreski believes that this is a no-brainer as far as at least putting it in front of the jury. And remember, we have 14 jurors, 12 will be finalized. There were some critics and the experts we talked to every day that felt like, oh, this is a little strange and a little concerning that there's only 2 alternates. But so far, in a quick trial, 7 days, we got 14, and we'll see after closing arguments what they will decide as far as who's the final 12. But just a lot of evidence that we saw today. I think it is perfect timing for the state to rest their case.
Yeah, you have to wonder if this was the plan all along, or was this something that Trina Kay kind of figured throughout the day? Like, look, this guy's doing exactly what I need him to do and present what I need him to present. She controlled a lot of the testimony in such that she was asking a lot of questions and getting Detective Duncan to really say yes, no, whatever. And you wonder whether she or her team was monitoring the jury and felt like, look, I don't need to call up my last 2 detectives. He's hammering home what I need him to hammer home. This is what the jury needs to hear. This is our case. We're done. Good
Mhm.
luck, Lori.
Trina says there's no self-defense. There's a $1 million life insurance policy that Lori thought that she was going to cash in on. And then there's this romance. We finally got to see that today. We hadn't heard much about Chad Daybell. You heard about Chad Daybell in opening statements. The jury doesn't know he's on death row for killing Lori's kids, as Lori's also convicted of killing her two youngest kids, JJ and Tylee. But the love affair was presented. The story of James and Elena was brought in. They didn't read the whole thing, but obviously people could get the picture. A lot of people watching our coverage and in the chat are just kind of like, cringing because they remember this from the Idaho trial, the loin to loin, cheek to cheek reference, and how Chad and Lori were basically talking to each other every day, giving each other multiple reminders of their love for each other. Meanwhile, Lori Vallow is married to Charles Vallow. He's finding out about this affair, and the jury's now seeing her go after witnesses and make Charles look like a bad guy for talking to other women. So this tone has been set. Let's hear Trina's direct exam on Nate Duncan regarding her not getting the life insurance.
And so we learned that Lori received a email indicating she was not the beneficiary, and later she had a phone conversation.
Correct.
Does this one appear to be sort of the earlier one because it references, I just got the letter from the insurance company saying that I'm not the beneficiary. It's a spear through my heart. Who do you think he changed it to? Brandon or probably Kay? He left nothing for JJ.
Correct.
Did that conversation go on? Wow, that's terrible. There's no way to find out.
It did.
And did Lori then tell Chad, I might be able to see when I get his computer on Sunday, I could check the email sent to the insurance company. It will show change of beneficiary. He must have done it recently.
Correct.
So we had seen, in fact, photos what appeared to be from a computer that were sent to Chad Daybell, correct?
Correct.
Showing that beneficiary change.
Yes.
So does that seem to match with, again, what Lori's telling Chad here about finding out who got that money?
It does.
Does Chad then say, it seems you would have to agree to change, maybe the name was forged, you should have a good paper trail to prove it, right?
Correct.
So he's trying to help her figure out how to get that money.
Now, just listening to that exchange, we were talking about how that may have been an opportunity for Lori Vallow Daybell to object upon speculation on behalf of Trina K.
Right. You can't get a witness to interpret what somebody else might have been thinking or what they might have been feeling. We noticed it right away. Like that was a great opportunity for her to object and say speculation. She didn't. And then I don't know if prosecutor.
It wasn't a question. It was a statement, basically.
And
Trina got away with it.
She got away with it and just kept going. And you can go back and look at this entire trial, and there were many instances like that where even those of us who are not attorneys could pick up on, like, even if you think you're going to get overruled, right? That's an opportunity to stop the pace and stop it. Let the jury see that you're paying attention.
So, we're football guys, but I liken it to you're just running the same run play and you're just going up the gut, first down. At some point, you got to do something. You've got to, object, do something in your game plan to basically stop them, stuff them. And Lori has not. She's objected to relevance a couple times. A judge just doesn't even say overruled. He just moves on, lets the evidence be admitted. So she's still learning as she goes. She will learn a lot for her next trial regarding Brandon Boudreaux and that shooting. But in this case, like you have been saying, Trina K has been in cruise control. And when she's objecting to Lori's cross-exam, it's mainly sustained, like a lot of the time, left and right. And we got to see that cross-examination where Lori's basically almost like disrespectful to the investigation, to Chandler's investigation, saying that Nate Duncan had not collected Alex's phone. She had not talked to her family members, like her mom and Summer Shiflett, and basically calling him the case agent and saying that he had not done enough by her questioning.
Almost implying they were a little sloppy in their investigation at times. I thought hammering home what for an average person would be great points. You've just presented all of these text messages between all of these people, but you never spoke to any of these people to find out more about what these messages mean. Fair point. Now, he came back and said, look, none of those people were there on the morning of July 11th.
Yeah,
of the
they weren't
shooting.
relevant.
That's my case. So, I mean, he had a great answer, but in my opinion, probably her best cross of the whole trial.
It was still, as far as the tone and how the confidence was there, but that may not matter because, like, does it make sense?
Mm-hmm.
Do the questions make sense to the juror? And to the jury, she even brings up the bat, DNA being tested or not, and how Charles' DNA, she says, could that have done something? Could have meant something to your case? And I thought this was important to say that you had all these people in the house. You had Tylee bring out the bat. It was her bat. Her hands are on it. Alex's hands are on it. You guys have all lived together at some point, including Charles. This would just be proof, testing it for Charles' DNA and even it confirming a match that he's touched it at some point. It doesn't mean he took the bat and whacked Alex in the head with it.
Right.
And then again, there was no blood evidence that they could see on the bat. And then this is where her comment gets stricken from the record because she says, well, what if Charles just pulled that bat from Tylee, like Tylee had said in her statement to police? And Trina was not having it.
Right. Yeah, she, this is where that slippery slope of what can be admitted, what can't. Trina was quick. She knows her stuff. She's had 2.5 years to put this case together, more than that. So she knew. I think she anticipated a lot of what we heard and was ready to make sure it did not get in the jury's ears, that it was stricken from the record. I don't think there was much that surprised her.
Bottom line, Tylee, Alex, anything from them is hearsay. That was ruled on before trial. So, but this was, I think, the best exchange or most interesting and fascinating for the cross-exam about Nephi, where Lori basically tries to educate Nate Duncan on the Book of Mormon and how what he said to the jury was basically, very, very influential. And she attacks him in this cross-exam. Let's listen.
4 different prophets in the Book of Mormon that are Nephi. Are you aware of that?
No.
Okay. So isn't it true that you really have no idea what I was referring to when I referenced Nephi in my text message?
I can only go off of what I see. I can't tell you what you're thinking or what you're trying to relay there. But based on my knowledge and based on talking to people about who is Nephi, that is a story that came up consistently.
You relayed to the jury that it was in order to kill. You relayed to the jury.
I said that the story was the same story and similar to Adam told.
Okay, and you said it earlier that was in order to kill. That I referenced Nephi. I will be like Nephi and you will be like Nephi. To the jury here today.
Ask a question. That's a statement, not a question.
Now, Duncan makes it clear that this wasn't an explanation to the jury, but what he had heard from Adam Cox, who was very key as a witness, Lori's brother, and talking about this whole Nephi-Laban story. But I think when you talk about all these versions of the Book of Mormon and versions of Nephi, I think the jury they may not be in that religion and understand, but do they just think that she's crazy? I'm just wondering what the jury's thinking at that point as she goes off on this tangent.
Well, we know that, look, there are a number of religions in the world, and we know at this point that Lori and Chad, Lori specifically, Alex as well, that they were all very religious people. Mm-hmm. But I think the common person, the average person, should be able to deduct that, look, no matter what your religion is, nothing in any of these religions should be enough to kill someone, right? So even if you don't quite understand the inner workings of the LDS faith and the Book of Mormon, at the end of the day, as a juror, you're probably taking away and should take away, no matter what it says, how many books of scripture, that it doesn't justify this type of crime. Yeah. And I think that in and of itself is enough, at least for Trina K, to say, look, we're going to talk about it. You're going to hear these terms, and you're going to obviously see them explain what these terms meant in their messages. But at the end of the day, none of it justifies what Charles got.
And we're not going to teach you about the Book of Mormon and who's who and why Nephi is important. But I do get why Lori is saying or trying to make it look like, Nate Duncan, you are using that against me and saying that the Nephi story was a directive to kill, and I didn't say that. She's defending herself. She's trying to do whatever she can do in cross-examination. So besides that, here we are. Maybe there's a chance that she decides to testify. I don't think so, but we're getting ready for closing arguments now Monday morning, and really less than 10 days, we could have a verdict. I think that's pretty amazing.
I mean, here we are. They said 6 weeks. We're 2 weeks in. We're not even finished with the second week, and both sides have rested, and we expect closing arguments to begin 10:30 Monday morning, and we know that Trina has plenty to say in her closing. Lori didn't indicate how much she has to say, but I would imagine she's going to have something.
Yeah.
Clearly not as much as Trina K does. And then we wait to see how long it takes the jury.
This is how Lori can do her testimony in closing arguments without having to be questioned by Trina K. Trina's going to go for an hour plus. We know that. She went long in her opening statement. She's going to try to bring it home. Lori said she's not going to go that long. She has no real defense at all. So, yeah, I know that window is open. But, yeah, it would just make sense for her to do basically her testimony through closing arguments. So tomorrow, jury instructions will be reviewed. I don't expect it to be that intricate with it just being one charge, conspiracy to commit first-degree murder. But for those of you wondering, we will have coverage of what goes down at around 10:45 a.m. In court. Jury will not report until Monday. But yeah, this is key. The jury has to follow these instructions to come to a verdict, and we'll have coverage of that. We'll see you soon on The Record. Okay, the time has come. We're just minutes away from starting this hearing. Continuing the Lori Vallow Daybell trial. Now, I'm just going to tell you guys right now, it is a spoiler, but it is newsworthy that Lori Vallow Daybell has confirmed she will not be presenting evidence in this case. So, jury's still not in front of her for her to say that, but it was interesting that she said to the judge, as of this morning, yes, I still feel the same.
Yeah, and it was almost, the answer was more of a question, or at least it felt like a question. Like she wasn't even 100% sure in her head. But
It's awkward.
I think we've come to the realization that if she hasn't made that decision, and you would expect that if you're a defendant and you're representing yourself, or if you're a defendant and you have any sort of idea that you want to be on the stand, there's some preparation that goes into that. Does it
Did you
sound
get
like she's
the state's email this
prepped
morning?
all that much?
I
can't
have a couple
imagine she's
revisions
gonna
based
that
on what they
far and
said,
be like,
but also
you know what? I decided
one
last
thing I need
minute
you
I
guys
want
to
to take
address
the stand.
is
I just don't. I'm sure her paralegal is saying, look, you either make the call now so we have time to prep, or just let's move on and get to closing.
Okay. I heard some of
you know,
that in the
05
beginning of
is
this.
more appropriate because that's the one that deals with deadly physical force.
It would be.
So why don't you guys talk about that? And yeah, I'll give you a few more minutes.
Okay, so not totally starting on time, but this is how things are going to go as the court
Yeah, we're off the record.
as the court is now off the record. They'll come back on to really go over the language of these jury instructions, and it is very and this is just for one charge, conspiracy to commit first-degree murder. And you guys are going to see how things get interesting in this hearing, and we hear more arguments are going to come up because both parties, Lori and Trina K, may not agree, and we're going to see that today.
Yeah, I'm interested to hear you ask the panel later about why jury instructions are so important. Are they more important for the prosecution or the defense? It may seem rudimentary for people, like me on the outside looking in, but they need to nail this down, and this is an important part, obviously, of the puzzle and the ending of this case, and what the jurors can make of the questionnaire, especially in a case like this, as you'll hear later on in this hearing today, why they're hammering out every little detail in this questionnaire.
Yeah, Judge Bresky going into his chambers for a little bit. He will be back, so we're going to chat with you guys right now. Won't keep you waiting too long. Thank you to 1,000 of you watching, and not a packed courtroom like usual, because obviously evidence is done being presented by Trina K. No more witnesses to call, and jury's on break until Monday morning. But just, again, I will say it was fascinating to, like, Lori can't just say, I'm done. She said, as of this morning, as of right now, I feel like I'm not going to testify. I'm not going to present evidence. You have no witnesses to bring on.
Yeah. You have no evidence to present, no experts, nobody in the chats. I would be, if I were a juror, that would stick out to me, that you provided no defense, even though you clearly throughout the trial it's almost like in some of her questioning, she wanted certain things to be out there. Like she wanted to say something that, Judge Bresky would kind of reel it back in. Look, this is not your opportunity for testimony. Almost at times alluding, look, you'll have an opportunity to take the stand in your own defense. And for whatever reason, she's choosing not to take that route. And as we've said before, that would have been great to hear. I think we would all love to hear what she has to say about July 11th,
Yep,
2019.
July 11, 2019. Now, just so you guys know, we're not going to look at the jury instructions. So the information that we're hearing and that you guys will be hearing from the judge as they read over some of these terms and what's quoted from the instructions, it's hard to make out exactly what's being asked of the jury, but you can sort of piece it together as they go down the list, questions, instructions, and we're going to talk to our panel about that today as they listen in as well. We have Mel McDonald, the judge, coming back on, Rachel Smith, Taylor Larson, and we have Kirk Nurmi as well, Jody Arias' former attorney, who's been in that courtroom and dealt with such a high-profile case. So we're going to talk about jury instructions, how important they are. Going into closing arguments, I think everyone's looking ahead now. What is Lori Vallow Daybell going to say? And Rachel Smith was the only one on the panel. After everything we heard in cross-exam, 3 experts that we talked to on the panel said, you know what, I think she's going to testify. I think that's where everyone was leaning, but Rachel said, no, Lori likes to be in control. And you can see that in her tone of voice, even when she's asked if she's going to present anything. She really has nothing. And in the first trial, there were no experts called. There were no witnesses called. She had not one, and she didn't testify. It was just the state hammering her for 6 weeks.
Well, and we said yesterday, too, that by taking the stand, you're opening yourself up to cross. And Lori doesn't strike me, anyway, as the kind of person that would want to be in that position.
No.
To be forced to answer certain questions related to her life in any capacity, almost defiant in that way. So, I guess we shouldn't be all that surprised. But I think we can take a lot, at least in the last 2 days of this trial, we can take a lot from how the prosecution presented the case and giving us maybe a small little window into how they're going to approach the next trial for the attempted murder of Brandy Boudreaux.
Here's what I'm seeing here through jury instructions. Lori is going to try to slip in language that could benefit her, so that maybe one juror could read it, and basically read it as in a way that helps the self-defense narrative. And
Right.
That is what needs to be figured out. That's why this is so important, because like Rachel said, the appellate court, this is critical. You get this right. Don't mess this up. These instructions have to be presented and read and understood and absorbed in a certain way, so that this process, this is really sacred.
Right. This is their one opportunity. And this would look bad if somehow,
Of course, yeah.
that this comes back and she ends up, finding a way to be not guilty. So I think that's why they're taking their time here. Again, they're going to have today to figure it out. They're off tomorrow, and they come back Monday. Again, the closing arguments will be interesting because, Trina's obviously, as we've said, very good at this, and will hammer home everything that she's hammered home in this trial. I fully expect her to take her time on Monday and methodically go through each element of this case, just remind the jury what they've already seen, but also, look, that this was not about self-defense, that this was a conspiracy to murder Charles and get the life insurance money.
And she took about 45 minutes in her opening statements. It was pretty lengthy, almost an hour, and she said that she'll go for more than an hour in her closing arguments. So this starts 10:30 on Monday. Judge is going to go over a few things, some housekeeping, and talk to the jury once they get in. And then we're going to have closing arguments. And then Lori's going to get her chance. So you could foresee them being done with closing arguments by the lunch recess. They're going to probably take a lunch then, and maybe they'll bring the jury back after that recess and then go over the jury instructions at like a 1:30 or whatnot. in that time frame, and then they'll get the case, and then we'll be waiting here, to see if they take more than the afternoon, or if they can stay late too. They can get dinner,
Yeah,
through the
sure,
court and say,
sure.
all right, we want to get this done tonight. You don't want to sit on this until through Tuesday.
Right, and the fact that they're doing this after the Easter break, obviously a sign that the judge doesn't want this to linger. I wonder how many objections we'll see from Trina during Lori's closing arguments. We've already seen her object to a lot of what Lori has tried to ask in crossing some of Trina Kay's witnesses. Yeah, I do wonder how long Lori plans to go and how long those objections will be and how frustrated she might be or might get when the judge says, look, you can't say that, you can't do this, you can't do that. So
There you see Lori Vallow Daybell getting seated. So it looks like we're about to get started with jury instructions. Hope you guys have fun watching this. This is not the most exciting thing, but it's very important. It's very crucial that this gets done right, and you're going to get insight into what Lori's thinking. And the question that will be asked, will she present evidence? Here we go.
All right. We're on the record in CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. Let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct, I had 2001 instead of 2021, and I corrected the case number. The first instruction at the top, page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state,
No objection.
from the defense?
On page 2?
Yes.
No objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence.
I want to hear about that because that's a standard given when we have a situation where we've heard about people like J.J. Tiley, Alex Cox, we've heard about Summer, we've heard about Detective Moffitt. None of those people were called at trial. So I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
Yes, as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required, and that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right, before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine, Your
Okay,
Honor.
what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
That it shouldn't be in there?
correct.
Well, if the parties are stipulating that it's not in there, I'll remove it. Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction. I probably should have brought my hard copy because you guys are working off a hard copy. On my computer, this is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then on the comments are not evidence, the reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talk to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state?
No, Your Honor.
Defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony. I would keep in defendant need not testify, and I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope, no objection.
All right.
Can we add in there something?
What's
Is this a
that?
time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary?
Voluntariness of defendant's statements? That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have jury not to consider penalty. Any objection to that from the state?
No.
Defense?
Nope.
All right, the state emailed this morning. I think the state wants the alternative presumption of innocence, burden of proof in the Rajis. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy, which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So we're requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt, is proof that leaves you firmly convinced, and that entire paragraph. Is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney. The defendant is her own attorney, so she is. I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period, and then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with the state's
Yeah, I
wording?
agree with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
So the decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're going to print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind. Any objection to voluntary act and absence of other participant?
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we have.
I'm sorry, you're right. I should have stated, I did delete flight or concealment. I don't think it's applicable in this particular set of circumstances. So then we just have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's going to change a little bit. I did the charged offense, each instance where it says first-degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first-degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, the definition of first-degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state?
No, Your Honor.
From the defendant?
No, no objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm going to have to do is we're going to print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I have changed it.
I was going to ask for those to be added, so I
Okay.
did review them with my advisory council.
All right, I want to make sure, though, that you are literally on the same page with what's going to be read.
Yeah,
So,
I would like them to be printed so I can see them.
all right. We'll come back to that when we get you a hard copy. What I wanted to ask the parties was, I initially included the Raji 4.04 for self-defense justification, but in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here, so otherwise the jury has to try to implant deadly physical force throughout this entire instruction.
I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A.
For what?
The 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing, or a,
Yes.
hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is? So. I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or crime prevention,
Correct.
in addition to justification, deadly physical force.
Correct.
All right. Those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises,
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
correct,
on the
rather
property.
than being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that, goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person. I'm not going to give justification in defense of premises. It requires that there be a criminal trespass. I think it's confusing to the jury also if there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
In lieu of that, Your Honor, then we would ask to add 418, 4.19, defensive residential structure.
Record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411. Trying to find 411, but my
So,
search is not.
I'm going to hop back to 418. 418 is not applicable. 418 applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle. So there's no indication that Charles forcefully entered the house. So I'm not inclined to give 418. Does the defense want to be heard further on that?
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
So 419, that's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry. Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the.
Right. So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I removed deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but at closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred. Then I have knowingly, willfully, knew. And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. then the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state,
No, Your Honor.
from the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice, because I deleted the completed act definition of accomplice. So this says accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry.
Act.
Act was a previous page, sorry.
I kind of did it in alphabetical order, so accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definitions section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Okay. But other than that, you don't have any that come to mind?
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury foreperson and the closing instruction, and then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing the 1 ST as well to first degree.
Okay. There's no, we don't need any interrogatory on dangerous. It's automatic, right?
It would not be automatic, I
It's
don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so
determination.
that would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. Those last, first of all, any other definitions that you think need to be included that I didn't include?
Hold on 1 second. Your Honor, we had missed one that we wanted added, was mistake of fact, 205. I'm sorry, I didn't want to backtrack.
Oops. The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
Causation, ignorance of fact, is that what you're talking about?
Correct.
2.0401A, ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, 1, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or 2, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
Your Honor, it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot, you were being attacked, you weren't being attacked, things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact. It refers to a misunderstanding of the facts that would somehow negate any criminal liability. In other words, you'd have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact. So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. Review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday. When the jury comes in, I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point?
That's fine, Your Honor.
All right. And, well, anyone at this point can be released from your subpoenas, is that correct?
That's correct.
Okay. I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11, and then we'll still meet here at 10:30, make sure everything's good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments. All right, while we're here, I'm going to call the other case as well, CR 2022-001242, and the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th. at 9:30 a.m., actually 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting, though, the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial. For May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here, and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
All right, for now, we're setting the final trial management conference May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning, actually, about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talked about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th, and if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through, is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
All right, the state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date, or they're deliberating later. So I would ask they be screened through July 3rd.
11, 12, 13. That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June, so
What's that?
Didn't we screen these jurors through the 15th of June? So,
No, May.
I'm sorry, of May. So
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal, just.
We can confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town. With that said, the current last day is May 11 on that trial, so as defendant want to make a record because I am going to exclude time. I know you object to the exclusion of time.
I object to not having it by May 11th, correct.
You want to,
What?
do you have anything further than that?
No, just that, yes, that I would like to have my speedy trial by May 11th.
All right. Well, we screened the first trial through May 15th. You can't do, and the state can't do, and I can't do 2 trials at the same time. Additionally, the state indicated they need to make arrangements for out-of-state witnesses to come well in advance of the trial. There's scheduling issues for myself. I'm out part of the week of May 19th. I'm out and coming back early the week of May 26th to do jury selection. Additionally, I guess the delay is of minimal prejudice given the current sentences that you're serving. For all those reasons, the court will exclude time from May 11th. The new last day will be June 30th. All right, let me get these jury instructions, an up-to-date draft for everyone. Please stick around. I'll have my staff drop that off hopefully in the next 15 to 20 minutes. And then, again, when you review those over the weekend, please alert staff through your advisory counsel or your paralegal if there's an issue, because we're going to have those all printed out Monday morning if we don't hear from anyone by about 10 a.m. Again, we'll ask my staff to contact the jurors and have the jurors report for 11 a.m. on Monday.
And Judge, is the court able to just email those to me, or do you want me to stay here and wait to get a hard copy?
I will email them to you and advisory counsel and the paralegal, but if you want, you want a copy?
I'll wait for a hard copy.
Yeah, I'll print out a hard copy for the defendant to take with her here today.
Thank you. Thank you, Your Honor.
All right. Are you signed up for that? Okay. All right, thank you.
Okay, so that was jury instructions, riveting stuff.
That's right. The most exciting part of this whole saga.
Yeah, and for those of you watching, I appreciate the 1,600 of you watching. So it's important. We're not getting the full instructions, but you're seeing some of the terms that the defense may have issues with, or the prosecution may have issues with the language, and we're going to get to our panel in just a moment so we can talk about that language and just why this is such an important part of the justice system. And so we're going to closing arguments, and Lori is not going to present any evidence.
Yeah. Yeah, well, the panel can certainly better explain why the jury instructions on this are so important. It obviously is going to be important in a potential appeal, should she be found guilty. But yes, on the surface it seems boring, but there were some nuggets that you and I both took out of this hearing this morning. Obviously, we won't be able to see that just yet, but I think this is again all part of an important part of the judicial process. And so I'm glad that we have as many people sticking around for it.
Okay, so we have some questions, and these we can answer. But is Lori representing herself in the next trial? Yes, she plans to represent herself, and you just heard her there saying that she wanted to have her speedy trial for May 11th. And this is the case regarding Brandon Boudreaux, her ex-nephew-in-law. But as Judge Boreski explained, they had this first trial screened through mid-May. They were told by Trina K that it would take 5 to 6 weeks, at least 2 weeks to present her case, but they weren't sure what evidence or what witnesses Lori Vallow Daybell would have, so you play it safe, conservative, and now you have 5 to 6 weeks of trial. He says it time and again, like, not like he's impressed, but he's like, you got this done fast, Trina. You did this in 7 days, and Lori has no evidence to present. So here we are, and so he has basically moved that last day for the speedy trial out, and has reason to exclude time. And there are scheduling issues, and he's going to be either out of town or dark for a certain amount of time. And so we are waiting for jury selection to begin at the end of May with those questionnaires that will be sent out, those strike-through jurors, and we're looking at June 2nd, opening statements for the Lori Vallow Daybell trial number 2. And again, Brandon Boudreaux, her ex-nephew-in-law, was shot at. Gilbert police believe it was Alex Cox, October 2nd, 2019. Brandon Boudreaux, also someone who had been deemed a dark spirit, according to the police report, deemed a dark spirit by Chad Daybell and Lori Vallow. So there's going to be a lot of similar stuff regarding religion coming out in this next trial.
Yeah, you wonder, Boreski, alluded to the prosecution. Look, we planned for 6 weeks. You took 7 days. I think if you read between the lines there, he's thinking we're going to run into the same thing again, where prosecution's going to have the case. They're going to have plenty of witnesses to call, but Lori will not. Obviously, you can't predict any of that, but I think even the judge will probably admit that they learned a lot in this first case about how Lori plans to set up her defense, which, as we know, isn't much at all. But also, it brings up a great point when it comes to jury selection and trying to get a jury for any trial. But when you have a case that is coming up on the summer months, most people are traveling. He definitely looks ahead and goes, look, July 3rd, that week, a lot of people leave town. So you're going to get a lot. If you put that out there, you're going to have a lot of potential jurors going, look, I can't be here that week. And you're going to run into potentially an issue where a lot of your jurors are you're going to have to exclude them because of that. And so, good for him for thinking ahead. He also knows too, he's moving on. He's moving, so he wants to get this wrapped up, and reinforcing to the prosecution. Look, you guys presented your case. The tempo was quick, and we got this done in 7 days. There's no reason why we couldn't do that for the next case. Also, the fact that they're going to have courts on Fridays in this next case, which will speed things up even more.
Yeah, I was curious to know, and yeah, they're going to have Fridays. As far as where Lori Vallow Daybell is being held, she's at the Estrella Women's Jail. That's Maricopa County Sheriff's Office. But for now, we're going to go to our panel of experts. Good to see them and talk about jury instructions. Got Rachel Smith, special prosecutor in the Idaho case against Lori Vallow Daybell. That was quite an ordeal. You're talking about a real 6 to 7 weeks there. That trial without cameras, and it was all audio. It was totally different from this one. The pacing just moved so fast here. And not that, you had dozens of witnesses in the Idaho trial, so of course that's why it took so long. Taylor Larson, welcome back. Charles Vallow's former attorney who helped him file those divorce papers back in January 2019, really exposing the whole doomsday belief system as described by Charles Vallow, really his divorce paperwork speaking to us from the grave by the time we found it in January 2020, a year later. Kirk Nurmi, former defense attorney for Jodi Arias, such experience in a high-profile case, many cases, but really he's been in that courtroom here in Maricopa County and dealt with the media, the publicity, and all of that, and he is here to join us again. And then finally, Judge Mel McDonald, former prosecutor for the county attorney's office, as well as U.S. attorney for the District of Arizona, and a judge for the Maricopa County Superior Court. Welcome back, all of you guys, with such insight on this case. We appreciate you being here. Going from yesterday, when we last talked, and we made our predictions on whether or not Lori Vallow Daybell would testify, here we are, and she says, as of right now, how she's feeling is she will not have any evidence to present. And you guys probably aren't surprised, but I'm going to go to Rachel first, who said she doesn't like to be out of control. She wants to be in control. And so you got it right. What are your thoughts about how things went down yesterday afternoon?
I think it's classic Lori. Lori tried to go after Nate Eaton a little bit. I mean, Nate
Duncan, yeah.
Duncan, a little bit. She tried Nate Eaton earlier, but and so her effort to work her point of view in was seen in the questions, especially the slipping in what Tylee said to the police. So I think it unfolded as the way we would expect Lori Vallow to act. She thinks she's in charge. She's going to try to control things. And I think in closing argument, we're going to see her do more than what she did, even with the witnesses. I think she's going to have her say during closing argument.
Yeah, and you saw, she still has the chance to change her mind because she needs to officially rest in front of the jury. And Judge Boreski reminded her, hey, we're going to have the jurors come in Monday morning. You're going to let them know that you're resting your case, right? That's still your intention. And so these subpoenas that you've basically served on certain Chandler PD officers that you've already cross-examined, can you release them now? And she's like, okay, I'm fine with that. So the last step is her actually resting and saying that in front of the jury. She said in opening statements, the evidence will show that self-defense is not a crime, and the evidence will show that this is a family tragedy. Kirk, sum up her defense in cross-exam, because that's really all she's brought to this trial.
Yeah, I mean, I guess non-existent would be the best description I can have towards it, because much of what she brought up during her cross-examinations weren't necessarily relevant evidence. We saw her attack the lead detective over his lack of research over Nephi. We've seen her attack Mary Jo for having a date. We see her try to explore with Charles. We try to explore Charles's dating life, none of which has really been relevant to her defense. And one thing I want to address, though, when we talk about her defense and what she's put forward, we have a unique situation, and hopefully Mel can speak to this a little bit, but I have never had a situation where a defendant is afforded the opportunity to be so coy and say, well, not as right now, I'm not going to present a case, right? I could see how if the case wrapped early, a judge might give a defendant till the next morning, what have you, to hold her to that. But, he tried to convince her to get a particular answer, but she said, well, not at this time. I'm not planning at this time. He says, I'm anticipating you resting. Yeah. So there's that window open, and maybe this kind of comports with what Rachel says about Lori wanting to be in charge. She feels like she can kind of dangle this carrot at least a little more until everyone walks in on Monday morning.
Yeah, Judge Mel, I got to ask you, how would you have conducted this twice now? She's basically said, I'm going to rest, but there's that little 1% chance because the jury was not present today to hear her rest.
It was my understanding that was the jury down there, though, just not called into the courtroom.
No, the jury was not here today for jury instructions being reviewed.
I would have preferred, if I'd have been the judge, I would have said, you're resting Wednesday night. It is unconscionable to keep this case in such an undecided state. If she were to show up Monday morning and suddenly say, I've changed my mind, I now want to put on a defense, I want to take the witness stand, it is going to disrupt the entire layout of the proceedings. They've gone through jury instructions, they've gone through the instruction the defendant has to testify. It's just gamesmanship. And had I been sitting in the judge's shoes, we would have had that decision made in front of the jury Wednesday evening and then settled instructions today and had closing arguments on Monday.
Yeah, because you're right. They spent about an hour and a half or whatever it was today going over all of these instructions. And then she has said that the subpoenas can be, you can release them from those subpoenas. So if she were to take that, I don't know, 0.5% chance, and then she has no witnesses to testify. We know that. And then she takes the stand. Yeah, basically a lot of time has been wasted already, even though it has been a quick trial so far. Now back to what was said about Nate Duncan and questioning his investigation and cross-exam and getting into the dates that Charles Vallow has been on with other witnesses. Taylor, I got to ask you how it was to watch all these steamy text messages come out regarding the affair with Chad Daybell and the jury getting to see that side of the story.
Yeah, I mean, it's kind of, my reaction was kind of twofold. First, excited that we finally got to it. I know that people watching have been clamoring for these steamy text messages to be presented to this jury. And, most of us knew all along that this was going to be the final bow that Trina Kay was going to put on the case before giving it to the jury or passing the case to the defense. But the other part of my reaction was frustration, Justin. I mean, I said it on day one of the panel back on the first day of trial during opening statements that my number one, the thing I wanted to see the most was Chandler PD's testimony, law enforcement's testimony on the investigation of this and kind of why they waited so long to bring charges. Lori wasn't charged with this until 2 years afterwards, June of 2021, after she'd already been charged with the murders of JJ, Tylee, and Tammy, and a month after the kids' bodies have been found. So, and knowing what I know back when this first went down in July of 2019, I had Charles's family members reaching out to me, telling me, hey, can you talk to, the Detective Moffat, who's the lead investigator of the case, and tell him, hey, look, Charles foretold of this, and he said who was going to do it, and it played out exactly like he said 6 months ago, and really exposed the belief system that we put in those divorce documents back in February of 2019. And so, I reached out to Detective Moffat. I never got a call back. I never heard from any law enforcement after that, in fact.
Wow. And remind us of the time frame again of when you called.
And this is weeks after the murders,
Okay.
after Charles's murder. We're talking July of 2019. And I had multiple family members of Charles reach out to me saying, hey, here's Detective Moffat's information. And I told them, hey, I reached out to him, have him reach out to me because, he's not reaching out to me. And, I don't know why. I don't know why. That's my biggest question is why I was never contacted. Some of it may be that they were worried about attorney-client privilege, which is a valid reason, but they didn't even attempt to talk to me. And most of it wasn't even privileged because it was put in the court filings, which is, public record. And Charles even told me, hey, if anything happens to me, tell everybody that it was Lori and her brother Alex. So, to me, that's implied waiver of the privilege. And I still don't understand why it took so long for them to bring charges. And, you saw Lori yesterday go after them a little bit and she looked really, the most competent, I think, during the trial was going after the Nephi thing, going after, you didn't take Alex's phone, you didn't extract the messages, and Detective Duncan, he's in an awkward position because he wasn't the lead detective at that time.
You're right.
And so that was, he's like, well, if it was me, I would have done it, but I wasn't the lead detective. And, We don't have those messages, but so yeah, just to reiterate, it was very frustrating to see that kind of play out yesterday.
So maybe, guys, maybe that's when Trina K said, why am I going to put Moffitt on the stand to have him basically get ridiculed by Lori Vallow Daybell as far as the investigation, and how it looks like to many people that have followed this that Chandler PD dropped the ball. Obviously, Trina reinforces and redirect that a lot of information wasn't known at the time, but it looks like for Chandler, Nate Duncan was the savior on this case. Now, Rachel, you got to work with him, and I'm curious to know, after Idaho announced the indictment against Charles and Lori in the murders of JJ, Tylee, and Tammy, I believe it was about a month later that Maricopa County announced the indictment against Lori Vallow Daybell in the death of Charles Vallow. Like, was that timed? Was that all discussed as far as, hey, Idaho's going to take the lead here and handle this first?
I on this one, I have to be a little careful to make sure I don't violate privilege.
Okay.
No, let me do it this way, that it is not unusual that law enforcement will coordinate based on who has the most or the most serious charges. And so it is typical for prosecutors across jurisdictions to talk about who goes first and who has what evidence. And in this case, the similar situation happened. You plan based on who has the strongest case, who has the most charges, and candidly, who has the physical person. And very typically, that's who goes first. Idaho is the one who pursued and found Lori, and that was creative, excellent work by Rob Wood and the Madison County team. They found appropriate charges to try to find JJ, to try to find Tylee, and to force Lori back. So once she was in Idaho, just by practicalities, just by research, just by resources and strength of the case, Idaho went first.
Gotcha. Okay, that makes sense. Kirk, I have to ask you, I still don't 110% believe Lori when she says she's not going to present evidence or testify. Can you blame me? I don't fully believe her. What is it like if you were her counsel right now, like dealing with that enigma and that person who's just so unpredictable and has this, I mean, clearly an ego, no matter what has happened, just how do you deal with that?
Well, it's different because we have advisory counsel, right? And so if I was her lawyer, this would have been established a long time ago. So when Judge Mel says, what are you going to do? We have an answer for him right away. But ultimately, keep in mind that role of advisory counsel is a lot different. I've heard people commentate, hey, why aren't they objecting, things of that nature? They're not allowed to do that. She is the entire defense team, if you will. She's the head of it. She's the one who gets to make all these decisions. And obviously, testifying is something that's left to a defendant, whether they're representing themselves or not. But, if you have an attorney, you're working with that attorney to come up with a strategy. What we have now, and I agree with you, Justin, because, one of the things I thought was most interesting about this hearing, I've been with the jury instructions many a time, but for the judge to say, I assume you're going to rest in front of the jury, that kind of coy response at this time, what have you, whatever she said, makes me think like you do, that that door is open. I mean, we have a person who hasn't necessarily told the truth all the time and has an unclean mind.
So is there a chance, let's just put a little echo there. All right.
No, Mel.
It's coming from, okay, so hypothetically, and I'll ask you, Mel. Oh, the echo's coming from Mel? Okay. All right, I'll go back to Rachel on this. Or actually, this is what I want to do. We want to talk about jury instructions. So there was a point in this hearing where they discussed a certain question, and we sort of got an argument from Lori regarding defense and third-person defense. So I'd like to go to this, Robert, if we could. It's going to be bite number 2, court discussing the jury questions. You don't have those. Okay. 1 second. All right, in the meantime, okay, before we get to that, sorry, we'll get through these technical issues. Rachel, is there a chance that if she wants to testify, judge could say, no, you had too much time, and at the Monday late hour as the jury has just gotten there, or I don't know. I'm just trying to go through all the scenarios of what could happen.
Absolutely. In theory, that if Lori came in and said, I've thought about it, I've talked to counsel, I changed my mind, and I want to testify, in theory, the judge could tell. I think if Lori says she wants to now testify on the advice of advisory counsel, I think the judge is going to let her. It would be a terrible position to be in. If the court had nailed her down, as Judge Mel McDonald said, which is either last night made her rest in front of the jury or even brought the jury in this morning and made her rest, then he would be in much more solid, you're done. But I think if Lori comes in Monday morning and says she wants to testify, I don't even think the prosecution will object. So I don't think Lori's going to do that. I don't think Lori's going to let anybody be in charge but Lori. But it is very likely, should she do that, I really think the judge would be hard pressed to not let her.
From your experience being around her, I don't know, do judges, it looks like this judge has not, I want to say take it easy, but he's been very patient. He's given her some leeway. And there were times where I felt like Judge Boyce did that too. Is that a pattern? What is it about her?
Well, candidly, I don't think it's unique to Lori. I've tried other pro se cases with standby counsel. And even in that case, it was a case in rural Missouri for a double homicide, where the defendant insisted on trying his own case. And even going right after I rested, the judge took a break and gave Carl Hollis, that was his name, said, are you sure you don't want to testify? And he said no. And then we get instructions done. And then he came back and said, yeah, I think I want to. So the judge gave him a little bit more time, and then he changed his mind again. These pro se, I know in Arizona, a lot of people call it pro per, when they represent themselves, the courts, in my experience, the judges who are patient and thoughtful and mindful of that appellate record give pro se defendants a little bit more opportunity, so that the record on appeal is really clear that nothing happened to affect this person's rights. So the judge isn't really doing anything unusual in pro se cases. He's, in my experience, doing what judges do.
Gotcha. Okay, well, we're going to listen to her basically talk about her decision not to present evidence. We're going to go with bite one.
All right, we're on the record in CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence.
Okay, so just your thoughts on that, Judge Mel.
Judge,
we'll bring you back, maybe on your phone. Go ahead and turn that off. Okay, Kirk, let's go to you.
Yeah. Your question again, Justin?
Yeah, just your thoughts on how that was handled and kind of gauging her attitude and her, I don't know if that answer was very concrete.
Yeah, I picked up on the same things we talked about earlier. That answer isn't concrete. It does make me think that door is open. She's got, 72 hours or thereabouts to consider and go back and forth in what she decides. And, Rachel may be correct that she doesn't want to give the situation where she gives up control. I think she's going to go back and forth on it. And that door is open. I mean, until somebody rests in front of the jury, until the defense rests in front of the jury, that door is open. And if she were to pop in there Monday morning and say, you know what, Judge, I've changed my mind, I want to testify, Rachel's right that neither the judge nor the prosecutor could really object to it because she has an absolute Sixth Amendment right to do so. And he did not force her to close the door. And that's the concern that arises with the procedure that's taken place now, because, that does leave that door open. And obviously, Trina, I'm sure, would be well prepared to cross-examine Lori should she decide to take the stand Monday morning. But really, I think, some finality on that should be something that the court's looking for, because it will alter the jury instructions. Because keep in mind, we have instructions about the defendant need not testify, the defendant need not present any evidence. If she does testify, there could be other issues from which instructions might be appropriate. So, he's relying on her word, as you say, but she has consistently herself an out, whether that is to garner more attention, to get people to talk about whether or not she'll testify or not. I don't know, but the door's still open and it does concern me.
Taylor, is this the Judge Boreski that you know and you're familiar with?
It is. It is. But at the same token, I think that it's a little risky, as the others have kind of said, of him leaving it open. I'm not surprised that Lori is not really being committal on her decision, as of this morning, Your Honor, because it is a game to her. And I've thought this whole time that, this whole thing of her self-representing, it is about control, but I think it's also a game to her. She's shown zero remorse throughout the trials in Idaho and the trial here, because this is all a game and a charade to her. And she's a pageant queen. This fits right into her background, and she loves to be the star of the show, and she wants that light on her. And she knows if she holds it till Monday, she still has it a little bit more. I don't think that she's going to change her mind and testify because of the control thing, and she doesn't want to be cross-examined and given that control up of being able to control the narrative. So I do think it's just straight up gamesmanship.
Okay, we're going to get back into those jury instructions, so I want you guys to listen to bite number 2.
So we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of or crime prevention.
Correct.
In addition to justification, deadly physical force.
Correct.
All right. Those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises.
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing.
Correct,
on
rather
the property.
than being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person.
Okay, so I know that's a lot, and for the people watching and they're trying to figure out where is Lori going, Kirk, go ahead, and you've been in this, Arizona courtroom. Just if you could translate the language there for us.
Well, Lori's really trying to, this isn't going to sound very complicated legal analysis, but she's throwing everything against the wall to see what'll stick, right? She wants everything, to her knowledge of lawyering, she wants everything related to any form of self-defense, whether the evidence supports it or not. So she's going to push those issues. And one of the things we heard Judge Boreski say during this is, I don't want to risk reversal over blank. There just needs to be a slightest bit of evidence to support the giving of the instructions. So I think he is well advised to talk about assaults on the other, self-defense, what have you. And you can see he's really giving meaningful consideration to whether or not this property, unauthorized invasion of the property, is appropriate. I think he's probably going to wind up, I think the state's arguments were better taken on that, because like I say, Ms. Vallow just sees any kind of defense instruction that the jury is given as a good thing, whether it's actually supported by evidence or not. She's not doing that legal analysis. The state and the judge are.
Yeah, Rachel, we know that Charles did not trespass into that home. I mean, everybody here knows that he was going to pick up JJ Vallow, and then as far as the assault, again, he walked in to go pick up his son, from what we know.
Right. I agree with Kirk. Lori is throwing everything but the kitchen sink in there. And the goal is to confuse the jury, or at least one juror, because the more you can get them to fixate on one little thing, one little hook, the more complicated the law can seem to a jury, the more possible it is to get one or two of them to just hang it. So it's not unusual for people in a situation to try to just throw everything in there. The goal being to confuse the jury. The court is clearly paying attention to the law, clearly going to follow the law. And I think legally he would be very safe to exclude that one. Charles was on the lease. He was invited in there. It was his child. And we don't actually have any evidence he was ever asked to leave. So
Yeah.
I think the court will be able to exclude it, but Lori's strategy is something a lot of people do.
Okay, so Judge Mel, do you agree this is not uncommon? Trying to sneak in sort of a question or instruction that could possibly confuse a juror.
I'm sorry, I'm having difficulty hearing you. I'm trying to get the speaker working on my phone. I think somehow Lori's gotten hold of my connection. Let me go try to get some earplugs in,
Okay.
and then I'll see if I can hear you.
Yeah, technical difficulties do happen, obviously. Taylor, just your thoughts as Lori tries to once again smear Charles, even by jury instruction.
Yeah, I mean, there's two ways of her to play this defense coming into this trial, right? It's to claim self-defense, claim that Charles is this horrible person. She kept saying let the evidence show, yet she's not going to even present any evidence. So I don't know how that's going to play with the jury. Um, but the evidence I think, has shown the opposite. And these jury instructions are very, very important, as we've seen throughout some other high-profile cases, including the Karen Reed case in Massachusetts, which is just now getting ready for trial number 2 to start. And the issue from the first trial with jury instructions, being confusing for the jury on how to submit a verdict form, that was taken up through appeal, and I think is still on appeal. They're aiming for the U.S. Supreme Court in that case. So this insight that we were able to see today, even though I've never been involved in any jury instructions, I understand the importance of it. And it's kind of cool to see, the insight of the judge, the state, and the defense going back and forth with it, even with, Lori representing herself. Like Kirk said, it's only really the state and the judge who are doing the actual legal analysis of these things. But it is important to go word by word, because words matter.
Yeah, Kirk, what was this process like for you? How important are these instructions related to a potential appeal?
Well, I think, lawyers and all parties involved take them very seriously. But at the same time, when we talk about where the rubber meets the road, you don't know if the jury really even opens the packet of instructions or not. They might you might have a jury that goes through every word. You might have a jury that doesn't take a look at a lot of them. But they're important, for appeal. I don't think that, we got to remember here, to put in context, Justin, that probably somewhere about 5% of the cases are successful on appeal. That's probably maybe even being a little generous. So while you want to protect the record in that, it's not going to be a huge deal. Jury instructions also too aren't necessarily that much of a fertile ground for appeal unless they're blatantly obvious. If self-defense were to be laid off this case, something of that nature, Lori was not able to put that on the instructions. That really could be something for fodder. But when we talk about some of these other instructions, when the judge gives these well-reasoned responses on the record, because remember, this hearing today where they're discussing jury instruction is the part of the record that relates to the appeal. So if an appellate attorney says, you should have given the instruction related to him being there trespassing on the home and Lori acting to prevent it, the Court of Appeals goes to that record and they say, this is what the judge looked at. This is what the judge thought about and made, and judicial discretion allows him to make the ruling he made. Because one of the reasons why we have a limited amount of appeals get overturned is because judicial discretion is a big umbrella, and it's easy for a conviction to be upheld hiding under that umbrella.
Okay. Now I want to ask Rachel. We chatted about this morning via text. So a lot of people wonder why Charles Vallow's not being shown in evidence as far as body cam footage from Gilbert Police back in January 2019. Just can you tell me why we may not have seen more of Charles than people expected?
Yes. Under the law, the statements of victims, statements of witnesses who are not in the courtroom, regardless of the reason they're not in the courtroom, are not allowed to be played. They're not admissible. And so with the Charles not being available, then his statements, his recordings, like those with Tylee, they will not come in.
Okay, yeah, because I think a lot of people think that's huge evidence. Charles pleading his case to Gilbert officers and talking about Lori's mental health. But yeah, thank you for answering that. And I want to ask you, if you could play the role of Trina K right now, what does closing arguments look like on Monday to the jury?
closing arguments really focus on those texts. They focus on the 2 shots. This wasn't self-defense, stay away from me. This was murder. And focus on Lori's attitude and demeanor afterwards. And then I would spend a considerable amount of time helping educate the jury on what does conspiracy mean, what is not self-defense, and helping make sure that we don't have anybody sitting on that jury who is a sleeper, who is confused by the idea of conspiracy and confused by the idea that someone themselves has to actually pull the trigger or physically participate in the crime. Those are a couple of vulnerabilities on conspiracy cases that are you see a lot. Some jurors have trouble with the idea that words alone can be a crime. And so I would spend time with those jury instructions. I would spend time really making clear Lori's leadership and control and manipulation of Alex, and Lori's motive and Lori's attitude and demeanor, which shows her motive and her desire for Charles's death.
And like we've seen in other closing arguments, maybe some exhibits will be brought back out to reinforce visuals. Could we see the Walgreens video that everybody's been pointing out of Lori walking in and not barefoot, even though she had made a claim that she had ran out of the home after the shooting barefoot? Is that, I mean, wouldn't people see that's a lie? I mean, I see something on her feet.
Well, I think, yes, you will see visuals. It was a visual opening. There will be visuals in closing argument. The extent to which she relies on one piece of evidence that's subject to interpretation, that can be risky for a prosecutor. So I wouldn't anticipate something that people being, the linchpin. Sometimes the public or general normal people want that one I gotcha moment. This isn't a one simple case of I gotcha. There's no eyewitness left to talk about it. There is no one Charles will die today statement. This is going to be a very organized, concise, timeline driven, definition driven, very clean closing argument, which will lay a foundation and build people to that ultimate call of action, which is convict her of conspiracy to commit murder.
Okay, Kirk, you're the defense now. What is the closing argument going to look like or should look like for Lori Vallow Daybell?
Well, Justin, I gave up defense work so I wouldn't have to do this sort of thing. But okay, here you can put me in this position.
I got
here we
to.
go. One of the things that I would be focusing on is those 2 elements that Rachel just mentioned. In order to have a conspiracy to commit murder conviction, we need to have a conspiracy and we need to have a murder. Now, I think Rachel's right in her conclusions, but if I'm the defense attorney, I'm saying, wait a minute, ladies and gentlemen, look at all these instructions on self-defense and look how Alex Cox was not charged with a crime. And look at these instructions. You have to ask yourself, why does this help prove the state's case that there was even a murder? Then you go towards the conspiracy, and we talk about something that Taylor mentioned days prior, this idea of putting it all on Alex, whether you want to call him throwing under the bus, what have you. But we know that he did pull the trigger. So there's a little bit of leeway there to say, okay, this was Alex's actions. This was Alex's conduct. This wasn't mine, and divorce herself from that as best she can and try to sow seeds of reasonable doubt. Again, not saying that this is correct, not saying this is factually sustainable, but that's the only argument she has to make. The problem is this isn't what she did during the trial. And
You're
so
right.
I don't see her doing it in closing arguments either. We're probably going to hear more about Nephi and dates and things of that nature. But yeah, that would be the strongest argument that Miss Daybell has.
Yeah, she has not thrown Alex under the bus. Instead, she has said that the evidence shows that this was definitely legitimate self-defense. And she's talked about Charles as this more of a villain and someone who's intimidating. And she has talked about Tylee Ryan as someone that was trying to protect her mother. And that's where the jury just doesn't know what we know. And to hear that, Taylor, to know that she murdered her daughter and then uses her as a pawn in this as a reason for the self-defense.
Yeah, I mean, it's sad, but at the same time, no one matters more to herself than Lori, right? She is the queen. She's the know-it-all. She's the narcissist. She's the leader. And, so for her to just dispose of Tylee and claim, that it was Tylee who instigated this or was a pawn in the game, as you say, it's not shocking in the least to me. What is kind of shocking is that she really hasn't thrown Alex under the bus yet. And I don't, I agree with Kirk. I don't anticipate her doing so in closing, even though it's really her best shot that she has to say that he acted as a lone wolf and she had no idea that he was going, she had no idea that he brought a gun. She had no idea that he was going to shoot Charles, so we'll see what happens on Monday. I know I'm excited to kind of get this more wrapped up and get to a quick deliberation is my hope so that we can finally get justice for Charles and close this chapter on that book for him 6 years later.
Yeah, you bring up some good points. If she was taking the stand, she could have those questions scripted to say she didn't know what Alex was going to do. But she has never blamed him, just like in her trial, she never blamed Chad. Thank you so much to our panel for being here, even on an early day without a jury, and the state has rested its case. Lori Vallow Daybell has rested her case 99.9%. We believe we're waiting for that 0.1%. But you guys, thank you so much, and we'll see you for closing arguments.
Right.
All right.
Thank you.
George, here we are. Day 8.
Yes.
Is over, and we're heading into day 9, which is closing arguments, and then we're on a verdict watch, and it looks like we're going to have closing arguments at 1 p.m. Jury instructions, very fine, very intricate, and they're going to present those details in the morning to make sure the jury is good with that. And then closing arguments in the afternoon, they are going to do a lottery and choose the 12 or find out who the 12 jurors will be. Remember, we have 12 men and 2 women, I believe.
Yes.
There could be a possibility it's all. It doesn't even matter at this point. I don't know, but I'm just putting that out there.
Right.
There could be 12 men or 11 and 1. You know what I mean? Like, and then how long does the jury deliberation take?
Well, I think what we'll see, at least in my experience covering cases like this, the judge will try and get or gauge where the jury is after closing arguments and whether or not they feel they need to keep them even past, say, the 4:30 deadline on Monday. And figure out, do they keep them around through the evening or do they let them go home at some point on Monday and come back on Tuesday?
Mm-hmm.
Because you have one charge here, does that make it easier that you don't have to go through, line by line? And you can quickly go around the room. The foreman can maybe get a sense of where everybody's head is at.
Yeah.
Because they're only going to hear closing arguments after the lunch break. Right, so you're looking at a 2-3 hour period.
Hour and a half, maybe 2 hours right there.
Right, so it's not like they're going to have the whole day to listen to closing arguments and be, in theory, be tired and say, let's go home and sleep on it. It is after the holiday. That's probably helpful that they're not in a rush to get out of there. So it's all going to depend
They're
on
refreshed.
Yeah,
they're ready,
and they've gotten enough evidence up until this point, and 2 weeks of trial should still be fresh in a lot of their heads. But to Kirk's point too, like if how much of it will they read, and have some of them already made their minds up?
And is there 1 or 2 people who just aren't
That's all it
totally
takes.
sure? And because this is conspiracy, they have to believe and be convinced by the state that she planned this with Alex.
Right,
Let's
and
even forget Chad. He's out of the picture.
Right, and we haven't seen a smoking gun, right? We talked about that too. Like there isn't one piece of evidence that has her hand on the trigger, right? There's nothing there. So the conspiracy part is so open-ended, and we can talk about what we thought of the prosecution's ability to prove that. But at the end of the day, that still leaves a lot up in the air. And if you were a betting person, I don't know that you would know one way or the other or feel comfortable betting one way or the other.
So this is what happened in the Idaho trial, 2023. They had the case, I want to say, in the afternoon. At some point, they had the case. And they had pizza was ordered. They had dinner. And then they went home.
Right.
And then they deliberated more in the morning. So it's all timing, how everyone's feeling.
Mm-hmm.
Sometimes you got to take a breath and just have a meal.
Yeah, and those two cases, to be fair, were much heavier. I feel like the evidence, the case themselves, much heavier. You obviously you're dealing with children.
Yeah.
And we got a chance to hear from some of the jurors in those cases, and they kind of expressed the same thing. Like there was just so much that they kind of had to process emotionally, right? I mean, some of the jurors admitted crying in the juror box. This is not a case, that is as heavy, and maybe again that speeds up their thinking about whether she's guilty or not. But this also, and we can obviously ask the panel later, but this also I think gives us a pretty good idea of what we can expect in the next trial.
Okay, so this is what's going to happen. When we hear those closing arguments, it's a 30-minute delay, and we are going to come to you guys on the stream. And after the jury gets the case and, court is in recess or whatnot, and jury goes into deliberations, we'll be on here. Mm-hmm. We'll have our panel ready, and we'll just talk about those closing arguments. We'll be on. We'll stream, and we will stream. I will hope that we will keep on the coverage until we get a notification from the court either saying the verdict is in or the jury has gone home for the day. They'll be back at it tomorrow, 9 a.m., whatever that is, to deliberate. We will have that coverage, and we'll hopefully have our deliberation clock going.
That's right. No, we'll be ready to go. Keep in mind, and we may have mentioned this, there is the possibility that it could be streamed live. That that the 30-minute delay would be removed, but we're still waiting on that. Either way, we'll be ready. We'll have a crew outside the courthouse as well, getting reaction from those inside the courtroom about what they just heard. Mm-hmm. But yeah, we will be here waiting. We'll have it for you as soon as it happens.
We'll have it all covered because, that reaction from the courtroom, we'll have our reporter there. So we'll have that live report like we've been doing at times when we have Lauren Clark there. So that will be good to have. And then, if you get a verdict and that reaction to the verdict, family members and whatnot, we're going to have all that covered and just getting analysis from our legal experts. Hopefully we get all of them ready to go to be able to talk about how they think the state did with closings, how Lori did with closings. This is the first closing argument for Lori Vallow Daybell and could be very much her testimony, right? To say that this was self-defense, right? She said that the evidence will show that a murder did not happen. So let's see what she says in closing arguments. We got some questions here. People asking us, Brittany Hennick asking, what do you think the jury thinks of her behavior, Lori Vallow Daybell's behavior? I mean, that's a tough question. She's playing lawyer right now. Mm-hmm. For me, she comes off, and it's hard. We have these specific shades on for Lori. We know the context of who Lori is with her crimes in Idaho and what has been done here and what kind of the dots that have been connected, but she's still innocent until proven guilty right now. But her behavior, I think, comes off as argumentative and unpredictable.
Yeah, I think I don't think the jury obviously got to see all of Lori. You said it. I mean, we know her better than most just because of covering this and seeing so much footage of her and talking and her writings and all that stuff. I don't know that the jury got to see the full extent of who Lori is, but on purpose. Like you said, she's acting as a lawyer and a defendant. I don't know that anything was too much out of the norm. Yeah, there was a little bit of back and forth with the judge, some snarky comments she made after some of the questions for the witnesses. But I don't think, I would imagine that if you've ever been in a trial like this, you've seen a few defense attorneys or heard a few defense attorneys who are much more combative, much more condescending to witnesses than Lori was, that they are much more maybe even condescending or standoffish with the prosecution. I mean, that's what defense lawyers do. Yeah. They make it a show and they fight for their client. I don't think Lori fought for herself as much as she could have, but she's not a lawyer. But she didn't. I didn't get the sense that that she made too many waves in court. I think the most unusual part for the jury and what they should take away of her demeanor is that she is the defendant defending herself.
Yeah.
That to me is probably the biggest takeaway that they should have. But I didn't see, if I didn't know anything about Lori Vallow and I was a juror or I was just in the courtroom, I would have probably thought, well, I was expecting more.
Mm-hmm. The most fight we saw was probably yesterday in Cross,
Right.
with Duncan. And maybe she got a heads up somehow that, okay, the state's not calling anyone after this. I don't know when that decision was made by Trina K, but this is your last chance. It's like your last round in the boxing match. And
Yeah.
you just got to go leave it all out there. And so, I mean, did she do that? It's up to the jury to decide.
And I wonder too if some of the thinking going in was, hey, don't throw too much out there because you still have another trial.
Yeah.
We all know she has nothing to lose here. She's going back to Idaho. She's going to spend the rest of her life in prison there. This, without no disrespect to Charles and the family and Brandon and of course his extended family, but all of this for Lori means absolutely nothing, whether she's convicted or found innocent, other than a notch on her her badge of honor that she got out of a case or that she was able to beat a case, if that's how you want to look at it. But I don't personally, if like Taylor said, it's important to get justice for Charles, so his family obviously wants her to be found guilty. But I don't know that Lori has too much vested interest in this or the next one. But her legal counsel may be saying, look, you need to be prepared that whatever you were potentially going to say on the stand, is going to impact the next trial. And then Lori needs to make her mind up about how important this and the next trial are to her.
Yeah. Also, something we're tracking to see is if Judge Boreski allows us to take the verdict live without the 30-minute delay.
Right.
So
We're
we're
still waiting
hoping
on
for
that. Yeah.
a yes on that, so you guys can watch that in real time with us. Somebody asked if I was going to be in the court for the verdict. I'm going to be where I've been this whole time. We are going to have a crew on the ground for closing arguments, verdict watch, all of that. We'll get a heads up when the verdict is in. So we will be in place and we'll be ready, and I'll be watching that verdict in real time and talking to you guys right after that verdict is
We won't
given.
keep you waiting. You will get the verdict in real time. You may not be able to see it for 30 minutes, but you will know as soon as everyone else knows, and we'll be here.
And I think the message has been sent even just today. We have, jury instructions being reviewed. Not very exciting at all, but we definitely want to be here talking to you all about it and still bringing on the panel. That's been great, and they have been excited every day to join the panel and talk about what they see and the insight that they have. We're not taking days off just because the jury's not in court, and we want to bring you guys the best comprehensive coverage of this trial. And then we're just getting ready for trial number 2, so it's not stopping. So we're going to get ready to tape On the Record, get that episode ready for tonight, but we thank you all for watching, and we're going to see you Monday as early as 10 a.m. for closing arguments. Jurors will be expected to be in court by 11, but we will be ready for that, and we will have coverage and preview what closing arguments look like. It's going to be a long day, and then we head into verdict watch. See you soon.